So today's video is on copyright and the fair use doctrine, which is mostly in the United States Code Title 17 and tons of case law. So when I was on the panel with Chili DeCastro talking about free speech, some copyright stuff came up, and so I thought I would make a video about it. So about me, I'm Dr. Law of Discussing Law. Here's a picture of a kitty. So I have the picture of a kitty because just to talk about found images, all right? So it's very common in school when you're watching a presentation to have a slide like this, just a random picture found on the internet, right? Someone just goes on Google and types cat picture. Well, you used to have to click on the images tab, but now, all right, there's image results and your results immediately. They just find a picture of a cat that works and they throw it in their slide deck. So this is called, right, found images. You did not go to a place where they were offering open source or open access images like Pixabay or whatever. Instead, you said, I need content for this slide. I'm going to go and take it without really thinking about the rights of the person that created this photo, that you're not really taking into account the effort that they did, not really taking into account the amount of effort it would have taken me to create my own content to use here instead of stealing from the internet. And that's basically one of the biggest problems with theft of people's copyrighted material, is just people not giving a lot of thought about whose rights they're violating and into the work that they're saving themselves by stealing it. So there's the golden rule of copyright from Joseph McDonald. He says, take not from others to such an extent and in such a manner that you would be resentful if they so took from you. So I actually took this image from Pixabay, but I actually had to look for a while to find an image that looked unprofessional, right? That looked like something that you might just find on Google image search. Because I wanted to highlight that case, right? So if you took this picture of the cat and someone took it off of your website, or just pull it from Google Images cache of it without even visiting your website, and just stole your hard work for their own purpose, how would you feel about that? So we need to start taking that into consideration. So what is copyright? So copyright are the rights granted to the author of a tangible work of expression. Those copyrights include the right to reproduce the work, make derivative works based on the work, distribute copies, perform the work, to display the work publicly, and to broadcast the work. So a lot of what I'm talking about today is related to YouTube, so it's mostly going to cover, reproducing the work and making derivative works and distributing copies, maybe even displaying the work publicly, or maybe to broadcast the work. So let's cover what derivative work is. So derivative work is a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art production, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. A work consisting of editorial revisions, annotations, elaborations, or other modifications, which as a whole represent an original work of authorship, is a derivative work. So a lot of what people are doing by copying a YouTube video and using it in their own YouTube video is going to just automatically be a derivative work. When does copyright take effect? So as soon as the work is created and fixed in a tangible form, since it's been that way since 1989. Before 1989, you actually had to say that the work was copyrighted. You had to fix the copyright statement or symbol on there, as well as the date and the author's name. So usually the creator is the rights owner, unless it's done as a work for hire. So for a photograph, it's the person that was behind the camera that took a photo. So that's a common misconception, where people think that they're in the photo, so they own it, but it's actually the person that took the photo. Registration with the U.S. Copyright Office is actually voluntary. This is a misconception as well, at least within the trolls. The trolls think that Chili's videos aren't copyrighted because he didn't register them, but that's not the case. Registration does offer some additional benefits. So you may need to prove that you own the copyright to win a lawsuit for infringement, and registration is usually sufficient for that. So you may need to prove it because the defense isn't always going to realize that they should, require you to prove that you own the copyright to it. So if they don't bring it up, you definitely don't need to prove it. Elements for suit are ownership and copying of the work. So again, the defendants might not be smart enough to bring that up either. It's not the judge's job to do that. And then you may not be able to collect statutory damages or attorney fees if it's not registered. So to collect the statutory damages, which is X dollar amount for each infringement, the copyright code does say that you need to register it to get that statutory damage. And then your only statutory right to attorney's fees is from registering it. But attorney's fees often are up to the discretion of the court, or if, again, the plaintiff asks for attorney's fees and the defendant doesn't complain that they don't have a statutory right to attorney's fees, they might just get them. So you've made a derivative work of someone's video by including their video in yours. There's this defense called the fair use doctrine. So the fair use doctrine provides a means by which a court may ascertain the appropriate balance in a given case if the market actors cannot do so on their own. So this kind of means that really you guys are supposed to try and work it out, first of all. You're basically supposed to try and license it if you can. So fair use is a defense that can excuse what would otherwise be an infringing use of copyrighted material. To prevail on a claim of fair use, a defendant must convince the court that allowing his or her unlicensed use of copyrighted material would be equitable and consonant with the purposes of copyright. I kind of saved the purposes of copyright for my last slide, but it's really to prevent, fair use is designed to prevent a monopoly of the copyrighted material. copyright, of course, is designed to guarantee those rights to your work when you create it. So as to encourage you to continue to create works. So in order to make this determination, the court must carefully evaluate the facts of a case in light of four considerations, which are codified in the Copyright Act of 1976. So those factors are: 1, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. 2, the nature of the copyrighted work. 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So here, substantiality basically means significance to the whole of the parts copied. So Team Skeptic before has said things like, fair use can mean the whole video, but I've removed the boring parts of Chili's video. So because he removed the boring parts and just used the important parts or the heart of the work, it's basically the same as if he had copied the entire video. So the fact number 4 is the fact of the use upon the potential market for or value of the copyrighted work. These factors establish the contours within which a court may investigate whether in a given case a finding of fair use would serve the objectives of copyright. So that last part, these factors establishes, is not part of the fourth factor, by the way. All right, so then the copyright statute provides some fair use examples as well. They're not automatically qualify as fair use. They still should be weighed against the four factors, but they mention some examples, which are criticism, comment, news reporting, teaching, scholarship, and research. And of course, teaching and scholarship fall under that nonprofit educational factor. The other ones don't really fall into a specific area. Right, so fair use is often, this word transformative often comes up. Is the work transformative, the secondary work transformative from the original? And the word transformative isn't in the statute, but it's used to basically measure the purpose and character of use and whether it falls under the fair use. So whether the new work uses the copyrighted material itself for a purpose or instead uses it as raw material to make something completely different. And then there's this quote in some case law: copying that is complementary to the copyrighted work in the sense that nails are complements of hammers is fair use, but copying that is a substitute for the copyrighted work in the sense that nails are a substitute for pegs or screws or for derivative works from the copyrighted work is not fair use. So basically, a book critic's review or critique or a movie reviewer's critique is no replacement for someone who wants to actually ingest the actual book or movie. So a Hollywood blockbuster movie with people pausing the video to discuss part of it or talking over part of it is not going to prevent those who want to watch that movie from watching the movie separately. However, if a YouTube video content is created to entertain and a person copies that work also to entertain and not merely to critique or comment, it's usurping the market. So especially if what the trolls say is true, that Chili's videos are watched primarily as entertainment by those wanting to see his cringe-worthy behavior, and the secondary use doesn't change that purpose and may even advertise the original purpose. For example, in the thumbnail, such as Chili goes to court in the thumbnail, then that's obviously doesn't change the purpose. So parody, comment, and criticism must change the message appropriately and not merely poke fun for entertainment, or it's merely derivative and not transformative. For example, Team Skeptic says that his videos are transformative because he adds production value, but the fancy graphics that he doesn't make the work less substantially similar if Chili's video is still playing in the frame of the video. So commentary and criticism has to be valuable to the public, and comment and critique the content and not the speaker. And the reason that's relevant is because you're supposed to copy the least amount possible to do the critique. So if you're critiquing Chili and not the specific video that he's making, then you really don't need to include any part of the content. So to move on, so simply laughing, poking fun, and calling names is not valuable to the public. So it's not going to count anyway as criticism that transforms your video. And then Team Skeptic and some other people like to bring this up. The landmark case of Haas v. Klein, all the trolls like to quote for justifying reaction videos, actually interspersed short segments from the plaintiff's video with long segments consisting of defendant's mockery of the allegedly cringe-worthy features in the plaintiff's video. So the original video told the story of two characters, Bold Guy and Parkour Girl. You can't see what happens to Bold Guy and Parkour Girl by watching the Klein video. But if you watch one of the videos that basically includes the majority of Chili's video for the reaction videos, you typically can get all the latest updates from Chili, which was the primary reason for the original video that was copied. So additionally, Klein was not appealed, so it's not a final decision. And then lastly, Klein also makes it clear that Chili won't be responsible for the cost of litigation of his defendant since he had a good faith belief of the infringement. So we're going to go through the other factors. So fair use as a nature of the original work. So is it merely informational or creative? So and that informational material should be allowed to be cited and disseminated for public interest and shouldn't be monopolized by rights holders. And that's why they put that in the statute. Oh, so basically a work characterized as entertainment is less likely to allow a claim of fair use. But what we're seeing on YouTube is what's called infotainment. So it's not what they intended when they wrote this clause. They meant stuff like catalogs and indexes and compilations, news of public interest, and works intended to promote the progress of science. But even in those cases, right, some teaching materials, right, that they use at college and stuff, or LexisNexis that I have subscription to, is things that are developed for profit and they need copyright protection. So the courts now look at whether it represented a substantial investment of time and labor made in anticipation of a financial return. So this isn't merely informational or creative, it is now more defined that way. So generally, fair use defense has been found greater for factual or fictional works. So it's still generally true if you compile all the different case decisions, you're going to find that generally fair use has been found as a greater defense in for factual versus fictional works. So, but definitely the fair use would be for copying these works for the same scientific, scholarly, news reporting, or like purposes. You wouldn't be able to copy these and poke fun of them as entertainment and still get that fair use protection. So the next one is it published or unpublished? And this is also was more relevant until 1992. So the right to first publication is basically what this is talking about. So when you write a book or whatever, your book, usually you're selling the right of first publication in a specific market. And then the secondary and additional publications will often revert back to you, and you can sell those separately. But in 1992, there was an amendment to the copyright law that basically said, or before this was a given, right, that it was a hard and fast rule. Since 1992, it's no longer a hard and fast rule, but a factor that should be included. So there's also, if the owner purposefully unpublishes a work, this weighs against a fair use defense. And I know this has happened in some of Chili's works where he has decided to make a video private, and people continued to publish copies or make copies of those videos available. And it's been recognized by courts that the plaintiff has chosen to suppress the video, which is right, and so, but also the copy, his copy, is clearly now not in the market, so that the infringing secondary copy is the only market. So it's clearly no longer fair use. Right, so commercial use is also a factor. So the crux of the profit non-profit distinction is not whether the sole motive of the use is monetary gain, but whether the user stands to profit from exploitation of the copyrighted material without paying the customary price. The greater the private economic rewards reaped by the secondary user to the exclusion of broader public benefits, the more likely the first factor will favor the copyright holder, and the less likely the use will be considered fair. So you're better off if you have winning fair use if you aren't monetizing your secondary use. But this is one of the reasons why for-profit schools are restricted from making mass copies of materials for educational purposes, whereas the public schools, if they're teaching something out of a textbook and want to pass out a page in the textbook to every student, and it's the teacher's copy and the students don't have that, she can make as many copies of that as she wants. And it's considered fair use. Only case where that wouldn't be true is if there was a workbook that was being sold as well, and instead of buying a copy of the workbook for every student, she decided to make a copy. I always say she, like teachers are women, but so Kate would be much better off for fair use of her videos containing Chili's content were on her platform that wasn't set up for economic gain. So now we're going to talk about the fair use and the portion being copied. So here we look to the nature and objects of the selections made, the quantity and value. So here by value they mean qualitative substantiality. So the quantity of the content used, so like the seconds of video used in a YouTube video, versus the value, the qualitative substantiality. So if you, for like what Team Skeptic says, remove the boring parts, right, then you've reduced the quantity, but the qualitative substantiality is still the same or even more because you've taken the heart of the video. So the quantity and value of the materials used and the degree in which the use may prejudice the sale or diminish the profits or supersede the objects of the original work. So they also look at the fact that a substantial portion of the infringing work was copied verbatim is evidence of the qualitative value and the same message of the copied material. So each additional second of the original work that you include kind of shows that the value of your video is actually in the original that you're copying. And then, at least to the extent that the defendant may knowingly have exploited a purloined work for free that could have been obtained for a fee, to invoke the fair use exception, an individual must possess an actual authorized copy of literary work. And this is a majority opinion. But let's go back to these other two ideas. So whether the amount taken is reasonable in light of the purpose of the use and likelihood of market substitution. So it has a lot to do with the factor I'll cover after this, which is market or potential market. But definitely one thing is if you repeat a portion of the video that you've already shown, then that serves no additional biographical purpose. And I've definitely seen videos of chilies where they show the same part over and over, and that's definitely frowned upon. That's one of the opposite factors that definitely shows that it's no longer fair use. But as far as owning a legitimate copy to be considered fair use, I say this is the majority opinion because there are some cases where they've decided that you don't, because it could be argued basically, right, that if you have to pay for the copy, then you're licensing it and not using it under fair use. So there have been some courts that say that, but the majority opinion is that you do have to own a legitimate copy. So this is another place where Team Skeptic runs foul because he is downloading a copy of the video and then editing it, which is not allowed by YouTube's copyright rules. So you should have to at least license the raw material, right? So if you're making a collage, you have to pay for the paper, glue, and brushes. Why shouldn't you pay for the content on that paper by purchasing the magazine photos or digital files if you're printing them out on your own paper, right? So you're using this raw material. You should have to pay for that raw material. It only makes sense. And if you do that, then you have a right to be looked as fair use under the other factors. So and then because you now own, if you qualify for fair use, your work that you made, your secondary work that you made, if you now own the rights to reproduce that, right? So it's no longer licensed. So the whole argument where you have to, it's not fair use if you have to license it. Well, that's kind of broken down because you don't have to continue licensing it, but you do have to get that original raw material in a legitimate way. You're basically giving the rights owner the appropriate compensation for the work that you exploited to save yourself the time of creating it yourself, which is what we talked about earlier when we stole the picture of the kitty cat. So on YouTube, if you download a video and edit it, you pretty much don't have a fair use defense. Like Team Skeptic says his videos are more transformative because he does this, but he also is basically admitting that he can't qualify for fair use now. He also admits to only including the significant parts of the video, which is the same basically as copying the entire video. Although he argues that he could use the entire video because he's looking at Haas v. Klein. So the courts would argue that in general it does not constitute fair use if the entire work is reproduced. But people look at Haas v. Klein as allowing that. But in general, the courts do have a hard and fast rule that you have to have a pretty rare exception to have used the entire work and still be considered fair use. For example, incorporating substantially all of a short story in what purports to be a literary criticism of the story will serve to fulfill the need of those who wish to read the story, as well as those who merely wish to study the reviewer's criticism. So again, we're talking like in Chili's instance, where your video is usurping his market because it fulfills the same need as the original. So for this fair use portion copied, for the best protection for fair use, what you want to do is bring up YouTube and scrub through the video and make sure to include only the pieces or the least amount of the video as required to do your criticism or commentary. Okay, so this factor is the potential market. So this is one of the problems that I think Chile would have in bringing up damages, because it seems like some of the damages that he's had is that some of the criticism suppresses demand for his original videos as well. But there is this rule specifically related to criticism for potential market evaluation. So biting criticism merely suppresses demand, while copyright infringement usurps it. Thus, infringement occurs when a parody supplants the original and markets the original as aimed at, or in which the original is or has reasonable potential to become commercially valuable. So the courts do have to differentiate the difference between the demand, the suppressing of the demand that the criticism causes, but also you do have to look at whether it's usurping. And there's definitely, you don't have to choose one way or the other. There's definitely videos that do both of these. And then, does the secondary work usurp some of the market for the first by serving as an alternate means of acquiring the quoted material? And then transformation can help avoid this. And then, not only the extent of market harm caused by the particular actions of the alleged infringer, but also whether unrestricted and widespread conduct of the sort engaged in by the defendant would result in a substantially adverse impact on the potential market for the original. So what Kate could say is, well, I've only decreased, like there's only 1,000 people visiting my YouTube channel a day to watch his videos. Really, how much is that impacting? Well, when the courts make the decisions of whether you're infringing upon their market, is the court looks at if everyone was doing this, would that impact chili? So if there's 1,000 people going to your channel, 1,000 people going to infinite number of channels, it's definitely affecting the market. And then just to clarify again, so the burden is on the defendant to bring forward favorable evidence that potential markets will not be harmed. I don't know if I said it before, but fair use isn't a right, it's a defense. So what I mean by this basically is, like, if you killed someone, right, you don't have the right to kill people, but an accident, it was an accident or self-defense, might be a defense that you killed them. So basically what this boils down to is Kate would be much better off if her videos containing Chili's content weren't on YouTube, because right now they're both in the same market, which is YouTube content, especially YouTube content related to Chili. Then a thumbnail that advertises something like Chili goes to court or Chili releases another video and then contains Chili's video of that event are capitalizing on his rights protected content and not on her criticism of it. So these aren't codified additional factors, but they're additional factors that have appeared at times in case law. So there's defendant conduct, and I actually have a slide that digs into that a little bit more after this slide. But courts have found that First Amendment protections are rejected as a factor for fair use. Whether the infringer has created a new business from the wholesale copying of other people's content for profit is a factor, though, and I think this is going to weigh heavily against Kate, who says she was only making $200 a month or whatever until she basically started copying Chili's material. And then parody must create a genuinely distinct product and not just adapt another's original work. So I'm not really talking about parody here, but they have developed this additional factor for works on parody. And then internet previews of music have been rejected as a factor. And then harm to brand culture has been rejected as a factor as well. So defendant conduct is a fifth factor, and it's kind of codified in that the code says it has to be fair use is equitable. So right now they've said copyright isn't about virtue. Bad faith can't necessarily defeat a fair use defense. So this is kind of like where people say, well, Chili has admitted that he's a public figure, right? The state of mind doesn't make him a public figure, right? Being a public figure is defined by statute and the circumstances of the matter. It's not the state of mind. And then this is the majority opinion because there's some minority opinions, and it might eventually become the majority opinion that says bad faith shouldn't be used at all. But right now it can't necessarily defeat a fair use defense. And then together with that would be the opposite, right? So good faith can't necessarily justify fair use. And then there's some definitely clear recommendations in case law. They say if you attribute the plaintiff's work instead of denying copying it, that you have a better chance of using the fair use defense. If you don't paraphrase to evade plagiarization, so basically, right, if you rewrote Animal Farm, which is a book, and just changed the wording as much as you could to try and say it's not an exact verbatim copy. but still, the story is exactly the same. That is definitely going to count against you as defendant conduct that's not equitable. And then being denied permission doesn't ruin a fair use defense. Courts have validated attempting to get permission and invoking fair use only after being unable to agree on an appropriate fee. So there was some earlier case law that's saying, the attempting to get permission, and then when you didn't get permission, going ahead and copying the original work was evidence of bad faith. But the courts now say that it's the opposite, right? Being denied permission doesn't ruin a fair use defense. That in fact you should try and get permission, and then only invoke fair use if you're unable to agree on an appropriate fee. All right, so this is my last line. So this is the fair use determination. It's there's no clear test for it. Each infringement determination is a trial fact. The task is not to be simplified with bright line rules for the statute, like the doctrine it recognizes calls for case-by-case analysis. You have to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which that law is designed to foster. Copyright's primary object lies in the general benefits derived by the public from the labors of authors. So when you look at the four factors, right, you have to look at whether there's at least 20 people using copies of Chili's video. And does what's happening encourage or provide public good more so and encourage creativity more so than it stifles Chili's creativity at not being able to profit from his work? And that's what the court's going to have to decide. And I would argue that since the videos being made aren't specifically creative, not specifically funny, and are mostly, bad taste isn't necessarily a factor, but they don't really add to the public good. And they're definitely detrimental to Chili's right to his works. I think it's going to be it's pretty clear to me, especially when you consider some channels more than others. I'm sure the ones that are monetized are going to be weighed against more heavily. So, in fact, I haven't said that yet, but let's go to my fourth bullet point here. So there's no magic determinant of fair use, and that a dartboard may at times be the best predictor. This is actually said by a judge in a case opinion. But also, the market factor seems to historically have the most impact. So there's a review of case of decisions for fair use, and if you look at which factors had the most impact, it's definitely market. So I think that's where the Haas v. Klein and then the DeCastro v. Peter case is significantly different because they're both in the same market. So there's also basically case law that says parody artists, right? Because of the dartboard should continue to pay their insurance premiums because they're probably going to get sued. So to sum this up or to apply it to Chili's case, one of the huge mistakes that YouTube is doing by finding that cases are fair use under the DMCA, which he writes about in his latest supplement to his complaint, they're not supposed to be doing that, right? Their requirement for investigating mistake is based on whether the copyright has occurred and whether the notifier owns the copyright. A copyright claim will not be dismissed in court before trial unless the transformative nature of the secondary work is beyond obvious. So YouTube definitely can make that determination. The infringing defendants can't make that determination. So I also wanted to say, so this is the kind of end of the video, but I wanted to clarify. So there's apparently a rumor going around that when I was discussing free speech on that panel with Chili, that I said, quote unquote, there is no case law dealing with fair use, which I find hilarious because it's not true and I didn't say it. So I'm going to blame that on selective hearing of the trolls and also on the fact that Chili seems to have made that video private, so the trolls are probably having a hard time verifying the rumor. But to clarify, I said that there are no hard and fast rules to fair use, which you can definitely Google and find is true. I mean, I don't cite a lot of stuff because that's not the intent of this video. I'm sure that John Rietville, aka Merbeast, will try and pull up some stuff to prove me wrong. But basically, each fair use determination is a trial, and that neither the defendant, infringer, nor YouTube can make that determination. Also, it's clear, very clear, that there's no case law for Chili's unique situation, since we're saying that they're all case by case. There's obviously no case law for Chili's unique situation, and I hope that some comes up, but I don't know what's going to happen with the case. If you don't believe me that that's not what I said, then go watch the copy of the video that I'm sure the trolls made a copy of, because I believe in Discord that as soon as Chili's videos go live, someone's downloading them and putting them in some shared folder or something. So ask the other trolls if you don't have access to that, where you can get a copy. Because I definitely never said that. But I could see how troll selective hearing can make you think that. So that's it. I'm sure that John Rietveld, aka Merbeast, will prove everything I say is wrong by finding edge cases that I didn't cover. He's dumb, but if you don't like me, you may enjoy his naive coverage of my videos where he says I'm wrong, because he really can't help himself from arguing that I'm always wrong and he's always right. Have a good one. Bye.